Hello, this week we are going to talk about very important topics that I am sure you're going to use in your life. And that's why, of course, the course in business law must include these topics. And in a way, it's our grand finale because we are ready. And so the two chapters that we're going to discuss in this module are landlord tenant and insurance. So those two are somewhat related in an interesting way. And like I said, this is very practical for you to use in your life. So first, let's look at landlord and tenant. There's a relationship, and it's a special relationship. It's a subset of a lot of the things that we've talked about and build up to now. And of course, it's something that my students ask me about every year. There's somebody who's asking me about their lease, their landlord, and what can their landlord do and not do. And this is a very empowering topic, I think, for students in a business law class. So you all can probably relate to it as well, having had a lease, having had an apartment, or anticipating one sometime in your future. And this would even be for after you graduate, of course. So with that in mind, let's see what the topic will cover and introduce it to you. You've already learned about contracts and you've already learned about torts. When I say this is a special subset, I really am thinking particularly about those two areas that you've learned about already in this course. The landlord and tenant relationship ends up culminating in a contract, which we call a lease. And so you've already learned about the way that it's formed and why it's in writing because of the fact that it is an interest in land, that lease. We also have talked about assignment of contracts, and I've said to you, well, a great example is if you wanted to have a sublet of your apartment. That is a special kind of assignment. And students ask me this, can I sublet my apartment? And the very first answer in question is, what does your lease say? Because as with any contract, you need to look at the terms of the contract to see what your rights are and what your responsibilities are. And so if there is a clause in your contract saying that you cannot sublet it, then of course, the courts, as you've learned so far, when in doubt, if it comes to that, are going to support the landlord's right to require you to not lease that apartment. And if it doesn't say that in your lease, then generally leases, as in all contracts, are assignable. That's the general rule, at least, as you've learned about already. So that's a little bit of a review and how it applies to landlord tenant. And the other piece of that is the idea that something could happen on the property. There could be an injury, which, as we all know by now, is a tort. And because of that, we have to look and see, well, what are the liabilities? What are the liabilities, particularly of the landlord? We know rights and responsibilities of a tenant include paying rent. And part of the responsibilities of being a landlord, the idea of maintaining a reasonably safe premises, the language of negligence, right? Because if it is not safe, if there's a broken lock and a burglar comes in, if there's not proper lighting and someone trips and falls, then it's going to be something that the landlord potentially is responsible for because the landlord owes a special duty to the tenant, and the landlord potentially, this is how the argument would go, breached that duty by failing to maintain reasonably safe premises. What is reasonable? That depends on the circumstances. And as we know, is a jury question in determining under those circumstances. Is it a high crime neighborhood? Perhaps there was a better security system that should have been in place. Is this something that knowing there was a broken light or a broken lock? And by the way, how does the landlord know that? It's because there would be a duty to notify on behalf of the tenant. Okay, so we're looking at both sides, right? As in any legal story, rights and responsibilities goes both ways. And so with that, you would say, well, there was a responsibility and it's reasonably foreseeable that not having the lights proper or the locks working would then lead to an injury, which in fact is what happened. And there's your argument. So you can see already that as a landlord, putting that hat on, you would have to be very careful in maintaining the premises. And we're going to see what are the relationship implications for that special landlord tenant situation. So we'll look at that. And then we're going to swing into insurance, which I say makes sense to connect it because if you are a landlord or a homeowner, you should have a tremendous amount of insurance to protect you. And as a consumer, the same thing. Think about the risks of flooding, the risks of water damage or break in and what might happen to your property. And so insurance is really a broad topic that's for all individuals, consumers, and landlords and tenants. And really, it is the way you can shift that risk to a third party, being the insurance company. And I always recommend, especially when we're talking torts, I always recommend that you get a big insurance policy, as big as you can possibly get in terms of protection, because you don't know how far it will go. And I mentioned this briefly when we did our introduction as well to business organizations, because there we're talking liability, and you're talking about potential liability to third parties who might sue you, and they might sue you for mistakes that are made in the course of your practice. And I say it that way intentionally because that will hopefully spark in your mind, well, what about malpractice insurance for doctors, lawyers, accountants? And absolutely, that is a form of insurance. And that's an insurance that protects you from the ordinary kind of errors that might take place in your profession. And of course, that leads to a potential lawsuit with somebody suing you if it was a doctor and an error is made in surgery. That would be negligence, or could be, assuming it's proven, right? And so you're going to want to have, whether you're an accountant or a doctor or a lawyer, any other kind of professional, you're going to always want to have professional insurance if it's available in your profession. And that could help protect you somewhat in shifting your risk to third party. I say somewhat because, of course, every policy has limits. And as in any contract, you turn to the contract to see what is my coverage and what is the limit to which I can shift that risk. How much protection do I have here? And in a particular fact pattern, we look to see, well, was it covered by that insurance policy? You want to know this going into it, of course, and negotiate to the extent you can the most protection if you were the insured. And if you're the insurer, then you have the contrasting, I'll say, motivation and concerns that you're going to want to limit your liability. So whatever hat you're wearing in that situation as well, you see the different points of view and how you'd want to protect yourself. And even I want to say one other thing about the policy. With the maximum protection, there's going to be a limit really under the law as to how much protection you can have. An example of that, gross negligence. Gross negligence is not going to be covered by a malpractice insurance policy, even if it doesn't explicitly say that, which it most likely will to protect the insurance company. But even if it doesn't say that, there's that little element we learned about in contracts where an element of the contract, a clause, or a part of it, or even the subject matter, but in this case, we're talking about a part of it, may not be enforceable. Remember that fifth element of contracts where we said that if a contract is illegal against public policy, then it will not be enforceable. And I say not be enforceable, of course, there's somebody who's arguing it, and potentially you, if you were the insurance company and saying, we don't want to cover that. And an example of gross negligence, the surgeon, the doctor example might be that if the doctor went into the surgery drunk, well, your ordinary negligence is going to be covered by the malpractice policy. Remember the insurance policy. But do you think an insurance policy is going to cover somebody going into surgery drunk? We're going to call that gross negligence. And that's not something that we as a society want to enable you to shift to a third party. We want you, the doctor, to be responsible for your own behavior. So there's certain kinds of risks that we're not even going to allow as a matter of law to be shifted to the insurance company because we want the proper incentive. Remember, we're always thinking a couple steps ahead. We, the law, we, society, and we shape the law in a way that's going to get us the best results and incentives of our fellow citizens again. And so, therefore, there's going to be the lack of enforceability of terms that might be against public policy because they lead to results down the road that we wouldn't want. So you're not going to have coverage for intentional bad acts like fraud, taking it back now to maybe another profession like an accountant. If there's fraud committed, and you learned about fraud in this class, you learned about it as a crime. Could be a state crime, potentially a federal crime. It's also a tort because somebody could sue for fraud for the money damages the victim has. And then we can also have it as a contract offense so that if you used fraud to induce somebody into a contract, that would make that contract voidable if the innocent party wanted to get out of the contract. So fraud is a many splendored thing, and it comes to learning in the law. And as well, when we see fraud in insurance context, the idea is, well, what if somebody in their profession does not tell the truth, that they intentionally mislead someone to their detriment? That's fraud. And so then when we'll say, injured party, which is the plaintiff, or even if it's investors, right? Those are the plaintiffs. When they go to sue, they will not be assuaged, we'll say, from somebody having an insurance policy because they're not going to be limited to that if there is any coverage at all. And usually there's some kind of interest of the insurance company then to say, no, no, we're not covering this kind of money damages. And they will most likely be supported under the law because they can argue that it is against public policy to have that kind of provision in a contract, which is an insurance contract, be enforced. So this is a great way of tying together a lot of the things that you've learned in this course so far. And because I bet you followed everything I said and understood it, and if not, play it back again. That's the beauty of it being recorded. But I bet you did understand. And good for you if you did, because that just shows you how far you've really grown this semester in what you've learned and how sophisticated you are. And this is really useful stuff, as I'm sure you know, as you go out into the world to know. So you'll think, oh, good advice, get a insurance policy to cover the risks that I can cover, the things that I can shift to a third party. And then, of course, you're going to read that contract very carefully, as you're going to read your lease very carefully as a tenant and prepare it carefully as a landlord, because you know the importance of contracts, whether they're landlord tenant contracts, which we call a lease, whether it's an insurance policy, which is a contract as well. And you're always going to be much wiser for this to know that you're going to be awake, aware, and an advocate for your rights and very proactive and savvy. So good for you. I think this unit will be good for you, this module, as you conclude the course and go out in the world, and you will be ready. Enjoy. And this I could say enjoy because I think you'll find it really, really pertinent to your life.